नमस्कार दोस्तों, मैं हूं डॉक्टर भरत सिंह एडवोकेट एंड हम क्यूरेटिव जुरिस्डिक्शन ऑफ सुप्रीम कोर्ट की सीरीज में फॉर AOR एग्जामिनेशन आज नेक्स्ट एस्पेक्ट स्टडी करेंगे, दैट इज अशोक हुर्रा वर्सेस रूपा बिपिन जावेरी, दैट इज ऑल्सो रूपा हुर्रा केस ऑफ 2002 बाय द सुप्रीम कोर्ट। हमने पिछली बार देखा था कि कैसे व्हाट इज क्यूरेटिव जुरिस्डिक्शन ऑफ द सुप्रीम कोर्ट एंड हाउ इट derives reference from Ashok Hurra versus Rupa Hurra case, and today we will be learning about the same. The facts of the case is that it was a serious matrimonial dispute which arose between them. Mutual consent divorce मिल गया था इसमें under section 13B of HMA. Subsequently the wife had appealed against the Supreme Court order. Review petition dismissed हो गई थी, and thereafter Rupa challenged the order, alleging that the consent was obtained by fraud, coercion and misrepresentation. It was alleged that she was under mental pressure at the time of giving the consent. However, the review petition of the Rupa Hurra was dismissed by the Supreme Court. The court did not find any proof of coercion, fraud, it was not established. However, in this order, the mechanism for curative petition was established. Once the review petition was dismissed, the Rupa Hurra, the wife, used the statutory, she did not have any statutory remedy left, so she invoked Article 32, against the Supreme Court order. And this raised a lot of constitutional questions. What were the questions raised when a writ petition of certiorari was filed under Article 32? The questions were: can a final judgment of the Supreme Court be challenged after dismissal of the review petition? Does Article 32 allows for reopening and checking the validity of Supreme Court judgments? Is there any remedy under Supreme Court's inherent powers against gross miscarriage of justice caused by its judgment? And how to balance finality of the judgment with justice and fairness? So these were some of the questions that were laid down when this writ petition was being addressed of the Rupa Hurra. The aspects of the law that were covered in these judgments were, it decided on the finality of the Supreme Court judgments under Article 141. Endless challenges. The court said that the endless challenges to the judgment would undermine the judicial certainty. It would undermine the rule of law and the public confidence in the judiciary. This judgment also laid down the limitation of Article 32 in a way that a final order or judgment cannot be challenged under Article 32. Article 32 cannot be used as an appeal against Supreme Court judgment which has attained finality. Consequently, because it would create an absurd situation of infinite litigation, people would keep appealing against the orders and there would be no end. Writs can only be issued against subordinate courts and tribunals and not against coordinate courts. Now, with respect to the curative petition, this judgment introduced the concept of doctrine of curative petition, which is not explicitly mentioned in the Constitution. A curative petition can only be filed after review petition has been dismissed, when there is a violation of principle of natural justice, when the justice is biased, there is gross miscarriage of justice. Some of the examples that pertains to gross injustice or violation of natural justice are when somebody is not a party to liss, but judgment adversely affects his interest. When he is a party to the liss but was not served notice to proceedings and the matter proceeded as if he had notice. Further, where a judge failed to disclose his connection with the subject matter. These are some of the examples where violation of natural justice happens and a curative petition finds its ground. So what are the requirements for curative petition? It lays down strict safeguards have been laid down by the court, such as the curative petition must clearly state substantial grounds. It must be used sparingly and not as routine remedy. The petitioner must ever specifically that grounds mentioned therein had been taken in the review petition and that it was dismissed by circulation. Petition must have a certificate by senior advocate regarding the fulfillment of the above requirements. It is normally to be decided in chambers without oral hearing, and the curative petition has to be first circulated to the bench of 3 senior most judges and judges who pass the judgment which has been complained against, if available. Only when majority of the judges on the bench conclude that the matter needs hearing, that it should be listed before the same bench. Bench at any stage of addressing curative petition may ask a senior counsel to assist it as amicus curiae. Bench, if it finds the petition without merits and vexatious, it may impose exemplary cost on the petitioner. So now we have seen what were the kind of questions that were raised in Rupa Hurra, what were the facts of this case. We have laid down the facts and the aspects of laws that were covered and the procedure and the remedy of the curative petition mechanism. That's all. Thank you, friends.